So, first of all, I'm going to give the floor to Professor Sobrino Heredia. He's going to speak about tension, zone governance, and global governance in the preservation and management of fisheries resources. Professor Sobrino needs no introduction. In Spain, he is the president of the Spanish Association of Professors of International Law and International Relations, and that is quite a lot because he's the president of an association with more than 600 professors of public international law, private international law, international affairs. This implies renowned capacity to lead an association that deals with many topics, with many members devoted to international studies. And I must also say that he is the chair of this University of International Law. He is in the chair Jean Monnet of European Law, and he is also involved in a project of excellence at Jean Monnet on institutions and law in the European Union. He was the alma mater, the president of the University Institute of European Studies, Salvador de Madariaga, and he has done quite a lot for international European studies, not only in Galicia, in the Galician universities, but also nationally. He has been a lawyer in Luxembourg of the Court of Justice of the European communities at that time. So he has a long expertise and very wide knowledge in the field of the law of the sea. So this is a great opportunity. Therefore, we are at your disposal, Dr. Sobrino, to discuss this tension between zone governance and global governance in the preservation and management of fisheries resources. Thank you. Thank you very much, Mr. Chairman. Good morning to you all. My paper, as my friend Alejandro del Valle has mentioned, is going to deal with the tension between zone governance and global governance in the preservation and management of fisheries resources. To this end, after a short introduction, first of all, I will discuss how the process of illegal fragmentation of the seas and oceans has led to a zone regulation of the maritime fisheries, the strengthening of the role of the riparian states, and a proliferation of illegal fishing. In the second part of my paper, I will show how some group interests have been consolidated, and they tend to dismantle the zone jigsaw drawn in the UNCLOS, and they require a global governance, and we find some indications of that in the convention itself, but above all within the texts that after the signature of this great international treaty have been adopted in the international community. So I will start with a statement that you might all be familiar with. It's a demonstration of the concern of the states who signed in 1982 the UN Convention on the Law of the Sea. The states in the preamble stated that they were well aware that the problems of the marine environments are intertwined with each other and they must be considered as a whole. However, in the articles we find something else, because they broke down the seas and oceans into a multiplicity of spaces with well-differentiated legal systems and quite compartmentalized. Doing so, this text gave way to a zone perspective that had been developing all along the 50s, the 1950s, and it was moving away from the traditional vision of the sea, anchored, as we all know, at the freedom of the seas, and within this freedom, the freedom to access the fisheries resources, the marine life resources, that was open to all those who could enjoy those resources. Therefore, plotting the evolution of the international law of the sea means telling the story of the tension between a zone vision, in which the protagonist will be the riparian state, and a global governance or a global view, in which there are group interests, and they are trying to look for means, mechanisms, and tools to protect them. The fragmentation of the seas and oceans has led, as I said, to a global governance system. This has brought about a vertical and a horizontal compartmentalization of an environment which is unique in essence. This has brought about the multiplicity of declarations or claims of sovereign rights on the part of riparian states, of the fish stocks that were in their territorial and jurisdictional waters, as well as the possibilities of catches. This meant that 90% of the world fish stocks are under the financial sovereignty of the riparian states today. Since the convention, there has been an extractive race, and we don't know what the end of this will be like, except for the potential exhaustion of many resources. This scenario has brought about, has fostered fishing practices, and it has contributed to consolidate the protagonism of the riparian state on the basis of one idea, because they are closer to the resources. That's why they must have a special interest that must be protected, that the international society must protect, because they are so near the resource. On the contrary, the distant states are not nearby. They can go to some other places when the resource has been exhausted, therefore they will not have the same interest. This idea was consolidated in the 60s and 70s, and it specified in the 80s. On the text of the convention, I will not repeat the articles of the convention with regard to the management of the resources in territorial waters, in archipelagic waters or strait waters, the economic exclusive zone. But I think that we are aware of the strengthening of the sovereign rights over the natural resources, that is to say, the fishing resources in these waters. So what was the limit to that expansion? A thin line, a fine line, was set up at 200 miles off the coast, and they said there is not a special interest, there are some interests at play, and we need to strike a balance between these interests by means of cooperation. What type of cooperation? Well, it could be bilateral or within the framework of institutions that were established. But this line is very fine because it has been hit by a double manifestation of progressive jurisdiction unchecked of the riparian states, or at least some significant riparian state, an unchecked jurisdiction that is quite well known, which is the unilateral unchecked jurisdiction on the basis of the statement or of some special interest on the part of the riparian states about the resources that are in the areas that are adjacent to their EEZs. But there are other types of jurisdiction that today was controversial in the previous panel discussion. The institutionalized creeping jurisdiction that has been developed by several RFMOs, and they try to concentrate certain interests of some states, which hinder the access of other states that could potentially have some interest in those fisheries, but their participation in them is hindered. Therefore, they cannot implement a fundamental right, the freedom of fishing in cooperation with other states in the area. In the face of the protagonism of the riparian state, we might wonder Has this benefited the riparian states? Has it meant financial gain in the riparian states, an improvement to their populations, their communities that are connected with fishing? This is the first question. And the second question, has this led to a sustainable and responsible fishing? Has this led to a fishing that wishes to maximize resources as laid out in the United Nations Convention on the Law of the Sea? My answer is no, only in some exceptional cases. This has happened. I said before that 90% of the resources of the world resources are in the hands of the riparian states, but a quite considerable part of these resources are in waters of states that cannot guarantee that the fishing developed in them, the extraction of these resources, is responsible and sustainable. What is the meaning of that? Well, today there are huge marine spaces that nominally form part of the economic zones of many developing states, but they are unprotected and they are open to the plundering, pillage of fleets of convenience on states that are not too scrupulous. The riparian states are not in a good condition to have a long-distance fleet that can extract the resources they have a right to according to the international law, and they don't have the means to guarantee surveillance and control over these waters. This leads to dramatic situations. At a certain point, there are 1,300 ships off the coasts of Guinea, and only 50 of them can have a permit, and many of the catches in Western Africa are not declared, and the annual losses are 800 million euros. There's a contradiction between what was going to be beneficial by means of a zone governance of the fisheries resources and what reality has brought about. This is quite clear by means of another scheme that is being more and more developed in the international fisheries relations. Those states that don't have any connection with ships, and they open their flags, their records, their registries to fleets that are proliferating worldwide and which develop an illegal practice of fishing. This scenario, the scenario of a zone management of fisheries resources, is contrary to the interest of the international community as a whole, and they cannot react to that. And this leads us to a paradoxical reversal of situations with regard to the high seas. And this is quite a paradox. Today, some free waters are better preserved than many waters that are under the sovereignty and jurisdiction of the riparian states and which are unprotected. And this situation takes place specifically with regard to illegal fishing, which has been boosted by this zone governance of the fisheries resources. In my opinion, the zone governance that is based on the compartmentalization of the seas, and this is a contradictory phenomenon. Some states have increased surveillance and the ships go away, and some others cannot assume this surveillance, therefore the fishing boats go there. So this has brought about an illegal fishing activity. This has spread out from the high seas to the jurisdictional waters of riparian states that lack the means to protect their waters. Because why has this happened? Well, because the most interesting fishing resources, economic speaking, are in these waters. So 11 to 26 millions are given today. 15% of the global fishing is illegal. So a high majority of this 15% comes from waters that in principle should be covered by the financial sovereignty on the part of riparian states. Therefore, we are facing a manifestation of a formal or nominal interest on the part of the riparian state that comes into contradiction with the real interest of the international community as a whole. To solve this tension, to solve this contradiction is very difficult because we are facing the principle of sovereignty. If we don't solve that, it's going to be even more complicated because these illegal acts are attracting transnational criminal networks. The drift towards this criminality in illegal fishing is quite obvious because it will not only impact the condition of fisheries resources, it will also violate human rights through corruption, fraud, forging. It will hit the foundation of vulnerable public administrations of many developing countries. There are also some cases in the international practice, unfortunately, in which this illegal fishing is being connected with other manifestations of transnational criminality like people trafficking, piracy, etc. In spite of how serious this is, the Convention did not foresee that. Therefore, the international society has reacted to this phenomenon quite late. Once it began to adopt international texts, first from agenda kind and then legally binding instruments, these tools are going to introduce a new atmosphere, a more global atmosphere in the sea governance. It's going to be less zonal and it's going to be concerned with several interests for the sustainable management of fishing resources in the whole world. And we find some indications of that in the UN Convention on the Law of the Sea itself. It establishes the jurisdictional expansion of the riparian state, but it also sets some limits to this expansion, to this territorialization of the seas, and it supports the preservation and management of the seas and oceans, taking into account the interests of other states, the interests of the international community as a whole, and even the interest of humankind, and not only with regard to high seas resources, but also in connection with other resources in adjacent waters to the high seas. They are migratory or straddling species, etc. Within this framework, the Convention proposes cooperation for resource management. And what happened after the Convention? Well, most of the problems developed by global fishing take place midway between adjacent spaces at sea, and they have an impact on issues connected with the nature of the ship, its flag, or the activity of the ship, illegal fishing, etc. So this is a key issue that one of the previous speakers has mentioned, and I will talk about that by the end of my intervention. I'm referring to the surveillance and control of fishing activities. These are different fields where there is an interference between individual and collective interests, and zone governance cannot solve everything in that case. The global perspective has been found in international foray, and it has become integrated in programmatic texts, the idea of responsible fishing and sustainable development, and it shows a certain trend towards institutionalized administration or management of big marine ecosystems, and in order to define the pairing preservation management. but it has also given way to several international agreements. Some of them have already come into force, like the FAO agreement from 1993 or the New York agreement that has been referenced this morning several times from 1995. And some of them have not reached this stage, but they have set standard for international society. I'm referring to the FAO agreement about the measures of the states managing the port from 2009. In this foray, in these texts, the idea that the responsibility of the fish is not in charge of the reparting state or the flag state has opened up. It affects a group of states: the state of transformation, the state of marketing, the state of nationality of the seafarers, the fishermen who develop these activities. And it's the expression of an obligation that all these states have, the obligation to preserve the alive marine resources for the benefit of the international community as a whole. But this is not a linear process. It's a process which has many obstacles. But I think there are a number of steps within this process that I will list. The first step in this direction towards global governance is to confirm a reality that the space jigsaw had obviated, that of the global unity of the marine environment. The legal instruments that have been adopted within this field have reference such as the Convention on Biological Diversity, and they're going to highlight the approaches based on ecosystems, and this is adjusted to a global vision of the seas and oceans and favors a global vision or a global governance. Along this line, we also find a code of conduct of responsible fishing of FAO from 1999. Therefore, there has been a reversal of the unchecked jurisdiction of the reparting state towards the high seas. There will be a reversal, the interest of the international community, who is doing what the reparting used to do in their jurisdictional waters towards the high seas. This reverse process can be seen in Articles 63 and 64 of the UNCLOS, and also in the principle of complementarity established in Article 7 of the New York Agreement from 1995. These are regulations that limit the freedom of fishing, but not only in the high seas, but also the freedom of fishing in the EEZ. Some steps are taken with regard to illegal fishing from the point of view of governance, in terms of extending the number of individuals in charge of controlling these activities, and some measures are being adopted with regard to the notion of flag, the existence of the true link, and this link cannot be a mere declaration of the state. It has to be the outcome of a behavior, and if that behavior does not take place, measures will have to be taken, and that behavior or lack of behavior could be equal to a mere formal flag, a flag of convenience. And in that sense, to introduce all the mechanisms that different agreements have laid out, so the exclusive jurisdiction of the flag is not exclusive anymore, so it becomes a merely priority jurisdiction. So, in conclusion, the issue can be managed in terms of how to get to the implementation of the regulations, because in principle the implementation of the rules according to a zone perspective will be easier, because the reparting states can develop police actions. But the applicability of the rules, the compliance of the rules has two problems. First of all, the excessive zeal of some maritime powers that are exercising extraterritorial competences with the quote-unquote goal of protecting fishing, not only the high seas areas adjacent to their coasts, but also huge marine areas that could be of up to 1,000 miles. When this comes into contact with small archipelagic countries with huge oceanic seas, however, this reminds me of figures from the 19th century. Apparently, we are going back to mechanisms of maritime protection from the late 19th century and beginning of the 20th century, like the behavior of the United States of America in archipelagic areas like Kiribati or Vanuatu, or some others we might think of. And finally, the developing countries, how can they face the exhaustion of their resources on the part of foreign fleet? In the light of the weakness of this administration, some ideas have been discussed, and just briefly I'd like to mention 3 or 4 of them. First one is to accept as an evidence in a trial the electronic report of the satellite system, the introduction of a system of civilian sanction, the indirect limitation of the freedom of shipping by means of establishing the obligation to report, setting specific areas of passage, and this is all very good, but how many developing states can do that? Therefore, we need to look for measures of internationalization of the protection of the jurisdictional waters. I thought of 2, and I guess they will not be welcomed by many of you. The first one looks like a blasphemy: establishing RFMOs in jurisdictional waters of states that don't have the ability to survey their waters, replacing the non-operative fisheries regional organizations like the Council of Fisheries Management of the Gulf of Guinea with an organization that is open to the states of the region and the foreign fleet who wish to fish these resources in a responsible way, and introducing within these new organizations all the financial mechanisms that are possible, like those that come from the European Fund of Development, because we don't know how to spend those resources. We can help them economically within the framework of the Cotonou Agreement, which looks for regional cooperation and also in the fisheries field, and maybe we can implement the fishing agreements of the European Union there, and that are now called agreements of sustainable fishing, but I think they're just fishing agreements. And finally, to conclude, a final thought, which is not too original, but I think we could reflect upon that. Using techniques that are being used to fight unlawful activities at sea, like piracy, but we might use those to fight illegal fishing. You might say illegal fishing is not an international crime. Well, it's not, but it's a crime that, together with other crimes, might entail international organized crime. The only way to fight that is by means of universal measures, and in this case, with the due consent of the Security Council of the United Nations, and in a similar framework in which the activities against maritime piracy are being developed. Thank you very much. That's it.